While searching for information, do you keep finding lawyers who are just selling their services instead of answering your questions? With 24 years of experience, I am familiar with the frustrations you may be having while making an injury claim through an auto insurance company. I do my best to actually answer your questions in these videos and in my free book. I am Arizona native and attorney Kevin Fine, and in this video I answer your questions about what you need to prove in a slip and fall injury case. Some people still assume that if a customer is injured in a business, the business is responsible to pay for the harms and losses of the customer. That is not true. The business has to do something wrong that caused the injury before it will be legally responsible to pay. So what might the business have done wrong that led to an injury? This may be an oversimplification, but if a business fails to provide a reasonably safe environment for its customers, it has likely violated the law. As part of its duty to provide a reasonably safe environment, the business, its employees, should regularly inspect the property for unreasonably dangerous conditions. If they discover such a condition, then the employees should warn customers of it and fix it. Here's a common example. Water on a tile floor is likely an unreasonably dangerous condition because a customer can easily be injured by slipping on it. So a store shouldn't do anything to create water on the tile floor. And employees should be inspecting the floor regularly enough to find that condition even if it gets there some other way, like spilled by another shopper, for example. If the employees find water on the floor, they should warn of the danger, putting out signs, and fix the danger by cleaning it up. However, the store is only required to act reasonably. So if employees have just checked an aisle for cleanliness, 2 minutes later a customer spills water in an aisle, and 30 seconds later another shopper slips in it, the store would probably not be found responsible. Employees cannot be everywhere all the time. That would be unreasonable. But if that spill had been there for an hour, that may be viewed as too long between inspections to be considered reasonable efforts to discover dangers. There is not really any specific timeline requirement. What society would consider reasonable will vary according to the specific circumstances. The reason I am talking about this today is that recently, while eating lunch at one of my favorite restaurants, I watched employees of that restaurant violate a business's duty to warn of or remedy an unreasonably dangerous condition it knows exists, in my opinion. The floor in this restaurant is a dark polished concrete. A young man clearing tables, a busser, spilled water on the floor right next to my table. The area where the spilled water is pooled on the floor in 3 separate puddles. It's an area where both workers and customers walk. The biggest of the puddles was about 10 inches across, the other 2 were about 7 inches. This, I believe, caused an unreasonably dangerous condition on which someone could slip, fall, be seriously hurt, blow out a knee, hip, back, etc., followed by surgical repairs even. Within seconds, the busser grabbed a wet floor warning sign and put it out in the area of the spill. I was impressed. He had immediately given warning of the dangerous condition. He hustled away, and I expected him to return immediately with a towel or mop to mop up the water to eliminate the dangerous condition, through which the customers and employees could still walk, even with the sign there. However, that did not happen. Instead, he, other workers, and patrons spent the next 15 minutes stepping around the puddles. Yes, there was a sign on the floor, but it could have been easily missed by a worker or patron that was looking ahead or up, not down, who missed both the signs and the puddles. Given how easy it would have been just to clean it up, leaving the danger there seemed unreasonable to me. 15 minutes after the spill happened, the table-clearing young man came back and took the warning sign down. Since the puddles were still there, a little smaller by then from evaporation, but not by much, I assumed he was finally going to clean them up. No again. He just took the sign down. It took a full 40 minutes from the time the spill happened for them to be gone. Employees were aware of them and kept stepping over. When other diners ventured by, I warned them to step around. I have handled a few slip and fall accidents during my career. Even when the business is negligent, it is often difficult to prove that the business did anything wrong. What if, in the instance I just witnessed, a customer came around the corner of my table and slipped in that water, say 25 minutes after the spill? How would that customer know that an employee spilled the water there 25 minutes before and never cleaned it up? Or that it even had a warning sign up that had then been removed before the water was gone? A witness like me never exists, and this restaurant does not have cameras in the dining area. The employees might be witnesses, but what do you think they'll remember about this incident when they are testifying a year later, if you can find them? This is the most likely testimony. Spill? What spill? And if there was a spill, it was probably that guy sitting at the table, me, just before the customer came around the corner. So even if a business screws up, it's usually hard to prove, but not impossible. I answer more of your questions in my other videos, articles in my firm's website, and in my free book. Because your situation will be different in significant ways, the general information I presented here might not be right for your matter and is not legal advice. If you wish to talk to me about your concerns more specifically, I do offer a free consultation. You can set that visit up, or you can order the free book through the contact information on the banner below. Thank you.